Yes, Your Honours. It's case number IT 95-9/1, sentencing.
May we have the appearances?
Good afternoon, Mr. President. Your Honor, my name is Peter McCloskey on behalf of the Office of the Prosecutor, and I'm accompanied today by Gramsci DeFazio and Aisling Reedy, Janet Stewart.
And for the accused.
Good afternoon, Your Honor. Dan Brasic and Nikola Kostic for the Todorović defense.
Thank you. This hearing has been convened so that the trial chamber may deliver its sentencing judgment in the case of prosecutor versus Stefan Todorović. Judge Fassi Ferry, who is a member of the chamber, is absent because he is indisposed. However, he concurs with the judgment. I will at the outset present a brief chronology of the case before turning to the matters addressed in the judgment itself. The accused, Stefan Todorović, was initially charged in a joint indictment with 5 other accused for crimes alleged to have been committed in the municipality of Bosanski Samac in Bosnia and Herzegovina between April 1992 and December 1993. Stefan Todorović was charged in his capacity as chief of police in Bosanski Samac with 10 counts of crimes against humanity, including persecution, deportation, murder, and inhumane acts, 9 counts of grave breaches of the Geneva Conventions, and 8 counts of violations of the laws or customs of war. In November 2000, approximately 2 years after the initial appearance of the accused, a joint motion was filed notifying the trial chamber of an agreement between the accused and the prosecution, pursuant to which Stefan Todorović would plead guilty to count 1 of the indictment, and the prosecution would withdraw all other counts against him. On December the 13th, 2000, Stefan Todorović entered a plea of guilty on count 1 of the indictment. This plea was subsequently confirmed before the full chamber. Having satisfied itself that the requirements set forth in Rule 62 bis had been met, the trial chamber entered a finding of guilt against Stefan Todorović. The proceedings against Todorović were formally separated from those against the other accused at this time. At the sentencing hearing held on 4th May 2001, the trial chamber admitted certain witness statements submitted by the defense, as well as 2 expert reports on the medical and psychological condition of Stefan Todorović. The defense was given leave to call 2 witnesses, in addition to 1 of the medical experts, Dr. Leszek Tozewski. Prior to the defense presenting its closing arguments, Stefan Todorović himself made a statement to the chamber. Following the practice of the tribunal, for the purposes of this hearing, I will briefly summarize the findings of the chamber in this case. But I emphasize that this is only a summary and that it forms no part of the judgment. The only authoritative account of the chamber's findings and of its reasons for those findings is to be found in the written judgment itself, and copies of the judgment will be made available to the parties at the close of this hearing. The sentencing judgment is based upon the trial chamber's acceptance of Stefan Todorović's guilty plea and the consequent conviction of the accused on count 1 of the indictment for persecution as a crime against humanity under Article 5 of the Statute of the Tribunal. At the outset, the judgment addresses the gravity of the crime of which Todorović stands convicted. As the appeals chamber stated in the Celibici case, the gravity of the offense is the primary consideration in imposing sentence. This involves an assessment of both the criminal conduct, forming the basis for the conviction, as well as any aggravating circumstances. The judgment sets forth in summary form details of the criminal conduct underlying Stevan Todorovic's conviction for the crime of persecutions, including his participation in the beating and murder of Anto Brandic, the beatings of several other individuals. Stevan Todorović has also admitted participating in the unlawful detention, the cruel and inhumane treatment, and the deportation and forcible transfer of Bosnian Muslims, Bosnian Croats, and other non-Serb civilians in the municipality of Bosanski Samic. As a component of the overall gravity of the offense, the Chamber has taken into account as aggravating factors the accused's position of superior authority as chief of police in Bosanski Samic and the cruel manner in which he perpetrated several of the criminal acts underlying his conviction. In light of the above, the Chamber concludes that Stevan Todorovic's crime was particularly grave. The Chamber then examines any mitigating factors and finds that there are 4 factors in this case which may be considered in mitigation of sentence, namely the accused's guilty plea, his substantial cooperation with the prosecution, his express remorse for his crimes, and the question of his allegedly diminished mental capacity. The Chamber observes that Todorović is only the 3rd accused before this tribunal to have been convicted on the basis of a guilty plea. The Chamber recognizes the benefit to the tribunal in terms of time and resources when an accused enters a plea of guilty, and in particular when such a plea is entered early on in the proceedings, or in any event before the trial itself has begun. The Chamber considers that a guilty plea should in principle give rise to a reduction in the sentence that the accused would otherwise have received. And the Chamber observes that Stevan Todorovic's trial had not yet commenced when he decided to plead guilty. It recognizes the considerable contribution of Todorovic's guilty plea to the efficiency of the work of the International Tribunal and to its search for the truth, and it takes it into account in mitigation of sentence. The Chamber next takes note of the plea agreement pursuant to which Stevan Todorović has agreed to cooperate with the prosecution by providing truthful and complete information, and by testifying in the case against his former co-accused, and as requested by the prosecution in any other proceedings. The Chamber has regard to the prosecution's submissions as to the quantity and quality of the information provided by Stevan Todorović thus far, and it concludes that his cooperation with the prosecution to date has been substantial, and that such cooperation ought to be considered as a mitigating circumstance in this case. It is found that to accept remorse as a mitigating factor in sentencing, the trial chamber must be satisfied as to the sincerity of the expressed remorse. In this regard, the chamber recalls the statement made by Todorović during the sentencing hearing, in which he expressed repentance and remorse for his crimes, and a willingness and desire to contribute to the process of reconciliation in Bosnia and Herzegovina. The chamber therefore treats his remorse as a mitigating factor in determining sentence. In relation to the question whether the accused's alleged diminished responsibility may act in mitigation of sentence, the chamber found that neither of the two expert reports filed on Stevan Todorović's medical and psychological status suggest that his condition at the time the crimes were committed was one which would give rise to mitigation of sentence. As it is obliged by the statute and the rules to do, the chamber then turns to consider the general practice regarding prison sentences in the courts of the former Yugoslavia. It found that for the crime of which Todorović stands convicted, the punishment prescribed under the criminal code of the SFRY ranges from 5 to 20 years imprisonment. While it must consider the practice of the courts in the former Yugoslavia in imposing sentence, the chamber recalls that it is not bound by such practice. In the final section of the judgment, the chamber considers the relative weight to be accorded to each of the above-mentioned factors in determining sentence. At the outset, it is noted that the defense had urged a comparison between this case and that of Erdmovich, in which the accused was sentenced to 5 years imprisonment for his conviction on account of murder as a violation of the laws and customs of war. But the chamber finds that case readily distinguishable in that the trial chamber in Erdmovich considered duress as a mitigating factor, an element that is absent in this case. For that reason, the chamber considers that the Erdmovich case is not helpful in providing a benchmark for Todorović's sentence. The chamber reiterates the very grave nature of Stevan Todorović's crime. In particular, it is recalled that the crime of persecution is the only crime against humanity which requires that the perpetrator act with a discriminatory intent. It is found that the gravity of Stevan Todorović's criminal conduct was aggravated by his superior position and by the manner in which the crimes were committed. Indeed, the chamber holds that while mitigating factors have been given considerable weight in the determination of the sentence in this case, this in no way detracts from the gravity of Stevan Todorović's crime. It is found that Stevan Todorović's plea of guilty and his substantial cooperation with the prosecution are of primary importance as mitigating factors in this case. And the chamber states that had it not been for these factors, he would have received a much longer sentence. I shall now read out the operative paragraph of the sentencing judgment of this chamber. It is as follows. Stand, Mr. Todorović. For the foregoing reasons, having considered the arguments of the parties, the evidence presented at the sentencing hearing, and the statute and the rules, the trial chamber sentences Stevan Todorović to 10 years imprisonment and states that he's entitled to credit for 2 years, 10 months, and 3 days in relation to the sentence imposed by the trial chamber as of the date of this sentencing judgment, together with such additional time as he may serve, pending the determination of any appeal. Pursuant to Rule 103, paragraph C, Stevan Todorović shall remain in the custody of the International Tribunal, pending the finalization of arrangements for his transfer to the state where his sentence will be served. The registrar is reminded to distribute copies of the judgment to the parties. The hearing is adjourned.
All rise. Veuillez vous lever.